Welcome to Dental All Stars. I'm Alex Nottingham, founder and CEO of All Star Dental Academy. And with me is Michael Wild, Esquire. We got an attorney, another attorney in the house, and he is a trusts and estate lawyer. And we're going to talk about estate planning 101. Welcome, Michael.
Oh, thanks. Thanks for having me.
You were highly recommended by a good friend of the family, Uncle Jay, we call him. And he is a very successful medical consultant. And he said, Alex, and he knows money, he's good with it. And he says, you gotta get your stuff in order. You gotta put things in trust, do this. And not just him, but all of, in my mastermind group with our dentist, I hear a lot of about this, about the importance of protecting your wealth and about making sure you're building trusts and things like that. Now, I had a will. I had a few other instruments, but you gave me a gold star, not a platinum, but a gold star, but it wasn't enough. And so I got a great honor of working with you, and you did a wonderful job, not just building the trust for me and my wife, but also teaching us of how to utilize it to protect against liability. Because part of the premises with estate planning, I assume, and then I want you to say it in the more educated way, is what you do. But my understanding is it's how to protect your wealth ultimately, not just making money. Because I know a lot of dentists, and those who know my story of my father, he made a lot of money. Dentists make money, but you got to be able to keep your money.
Absolutely.
So invest properly. That's another discussion. But also whatever wealth you have, hold it from being sued and things like that. So tell me a little bit about. Well, actually, before we get into it, Michael, I mean, why did you even get into, let's just give me a little bit of background about you and how you got into estates and trusts. Why?
No, absolutely. So you're 100% right when it comes to, not just making your money, but keeping it. And that's why I always say the death rate is 100%, but the litigation rate is just under that. So, one way or the other, you're going to need asset protection, for future generations and for yourself while you're earning your wealth. Myself, when I started, so I've had this law firm. I started this law firm 15 years ago, but I knew I was going to be an estate planning attorney when I was in law school. I had this great estates and trust professor. He was hysterical. He would come up with these scenarios, and I still remember one of them. This was a real true scenario where a husband and wife without kids got their car stopped on the train tracks, and they got hit by a train, and they both died. And the parents of both of spouses were trying to fight over who got the inheritance, because if the husband died first, the wife got it, and then it went to her parents. If the wife died first, it went to the husband and then to his parents. Right. And an eyewitness saw the husband get decapitated and blood was squirting in the air, which meant that his heart was still beating, so his parents inherited. So it was such an interesting story.
I think I remember that case in law school. Yeah.
Yeah, it was it's
just crazy.
He used to give these scenarios of like, oh, his mother doesn't like his son, so she wrote her grandson out of her trust, but that way when they fly, he always puts her in first class and himself in coach, so when they hit the mountain, he inherits, and then it goes down to his son, and all these different scenarios. And even on the final exam, the essay was about a guy who was trying to hide money from his soon-to-be ex-wife. So it was very interesting. And then after that, I enjoyed that so much. And then after that, I took Intro to Income Tax, which sounds like it's a snooze, but it wasn't about learning the tax code. It was about how to get around it, like the maze and figuring out solutions. And so that's always what I wanted to do, the creative part of it. I was a litigator for a little while, but litigation's boring. Everyone thinks litigation is what you see on, Boston Legal or LA Law. It's not. It's just sitting in a room writing paperwork. It's horrible. It's research and writing. It's boring. But what I get to do is I get to have, like you and your wife, when you came in, we talk about, what do you have? Where is it going? Who's going to help it get there? Show me how your structure's set up right now. And I look through it. And with business owners, especially, I look and I say, oh, here's where you're going to get sued. I can just pick it out. So how do we fix that? How do we plug the hole so that way the dam doesn't break? So that type of creativity really always lent itself to my personality. And I love it. I love coming up with solutions to problems that clients don't even know exist yet.
Yeah, I really enjoyed, we were geeking out a little bit. I had so much fun flashbacks from law school, but I loved estate planning, wills and trusts. I loved the federal income tax. You can't learn the whole code, but just the philosophy behind it. And it's fascinating. And because I did the JD MBA program, mine was more oriented to business. And much like what you're talking about, this is a business oriented endeavor. And it's really the whole thing about law. Once you get past, I mean, when you're in law school, it's like, it has to be this way, right? But then it
Yeah.
really, as you get into practice, it's about how do we use the law to get your outcome? How do you utilize it? And it's an unforced error for those that are listening. If you have a level of wealth and you're not having conversations of how to protect it. And I think that was the hardest fun, but also a lot of the work is having those conversations about what's going to happen. How does it work? How do you, and it also, what's nice about the questions that you asked is helping to frame what you want in life and then having the legal instruments support you to do that.
That's exactly right. I
Make
mean, a lot
sense?
of people think the documents are what's important. You kind of alluded to it earlier that documents aren't the hard part. You know, it's funny. A lot of times clients would be like, "Oh, well, it's just some paper." I go, "You want the paper? I'll give you the paper. Like, you could have my documents. It's fine. It's the concepts of how do
Yeah.
we formulate your plan? Because not there could be two people that seem like they're the same. Two business owners. They're each married. They each have two young kids, and you're like, okay, same plan? Not necessarily. One of the children might have special needs. One of the children might have a gambling problem. One might have a daughter-in-law that they hate. You know, something like that, and those nuances to the documents have to be addressed because the document itself is a contract. It's just a contract with yourself. You're going to be gone when this contract actually is administered. And so when it's administered, it needs to be clear. There needs to be no ambiguity. There needs to be no surprise. It needs to be, okay, this is what I want done. This is how I want done. And just as simple as what we did for you and I've done for my kids. Okay, kids are too young. Kids, if I died now, I don't want the kids getting all the money right now. We have to protect them from themselves to a certain extent. We have to protect them from future dangers like divorce, creditors, litigation, bankruptcy, anything they might face. And those are conversations we have during that consultation. So ironically, the free consultation is the most valuable part of the plan.
That's true. So tell me, I have some questions prepared for you because it's good
Sure.
stuff. And I think you addressed it, but in like a nutshell,
Yeah.
how would you define estate planning in 30 seconds or
So
less?
to quote my professor Douglas Miller in University of Florida, estate planning is what happens to your shit when you die. So the
Oh,
idea
great.
of how does your stuff move to the next level? Now, a lot of people, and yourself included when you came in, think a will is enough. The problem is that estate planning, everyone focuses on the word estate. They're like, oh, I don't have an estate. I'm not rich. I don't have a palatial mansion. But really, it's death planning. It's planning for what happens to your stuff when you die. And that could be as simple as your house. It could be as simple as your baseball card collection. It could be as simple as your cash accounts, your retirement accounts, your life insurance. All of those things make up your estate. Now, the smallest estate that I've administered is probably $50,000 net worth. The biggest one is $2 billion. Now, I have concepts for each and everything in between. Because sometimes, like I had a client worth $100 million, no wife, no kids, giving everything to charity. There wasn't really much for me to do. Like he needed power of attorney and healthcare surrogate and stuff like that. But there was not going to be any tax issue. And he didn't need to have any restrictions because it was all going to charity. But then I have other clients that maybe their net worth is $1 million, but including their house, and they're worried because they have a son that's addicted to drugs, and we need to make sure
Mm.
that that son isn't going to inherit everything and then kill himself with the money that he inherits. So everybody has different desires, everyone has different worries, everyone has different concepts of what they believe their estate to be and what they believe their beneficiaries to be, and we have to kind of talk through what that is. So estate planning encompasses incapacity, it encompasses death, but most importantly, it's about the beneficiaries. It's about who are you looking to protect. If you don't have any beneficiaries and you have a bunch of assets, maybe it's not as important. But if you have beneficiaries that you care about, spouses, kids, parents, siblings, whatever it might be, then you need to focus on at least some basic estate planning.
And with respect, so we said is a will, well, you said a will and a trust is not enough. You need supplementary documents. But
Yeah,
in a sense, a will has to be executed in probate by a court, right? Whereas a
correct.
trust, if you do it right, probate's not initiated.
Absolutely. In fact, will-based plans we don't even create will-based plans because will-based plans are meaningless, except for the fact that if you have a minor child, a will appoint a guardian for your child. But if your children are adults and you have a will, the will still go through probate. A lot of people think wills avoid probate. They actually, the definition of probate is the proving of the will. So what happens in that process is the will gets filed with the court. It becomes public record. Anyone can see it. So everyone can see
They can
what you had
contest
and where
it.
it's going. And then with your death certificate, and we start that process of appointing an executor. Just because you put down who you want to be the executor doesn't mean they become the executor. They have to meet certain thresholds. The court has to approve them. Once they become the executor, they get a letter of administration. They can step into the shoes of the deceased person, and that's where the fun begins. Because then they have to deal with creditors. They have to deal with beneficiaries that are fighting. They have to deal with ambiguities in the will. They have to deal with all these different things. The probate process usually takes between 6 and 18 months if it's not contested. And it usually costs somewhere between 7 and 10% when we talk about, including all the filing fees and the lawyer fees and the, creditors and
Wow.
things like that. So we can avoid all of that with a revocable trust. And the revocable trust is so important because it does exactly what you were saying. It avoids all probate and can provide some protections in addition.
And when you die, the revocable trust becomes irrevocable, and there's a
Exactly.
trustee. Now, I don't want to get too much in the weeds, but is the trustee still subject to probate or contesting or things like that? I mean, I guess you could file a
No,
lawsuit.
that's the great thing. So the trust is a private document, not a public document, and the trust can't be contested because
Oh,
unless the trustee is actually doing something wrong. So the trustee
against
can
the
be watched
trust.
over, but
Okay.
your wishes cannot be contested. So once your trust is set and it becomes irrevocable, and you say, "Well, I want my son to receive 30%, and I want my daughter to receive 70%," your son can't contest that now unless he can show that there was fraud. Fraud, duress, and undue influence are
Sure.
always aspects of it. Like it wasn't his
But
signature,
we're getting
something like
legal
that.
here. There's a presumption that this is settled, and there would have to be a separate lawsuit to try to unwind it or something like that. But it's not where by probate, a will, I like what you said, a will is executed in probate. So in this case, there's a presumption that the trust this goes on, and then they have to go and break it there. So what for the listeners is becoming more ironclad. And if you think about it, you're like, do you want this ambiguity when you die to create more suffering for everybody around you, and to also have lawyers get a lot of the money at that point, and fighting and things like that, or get it set up, be very clear as you talk about with it, and also just a note, which you've talked about, is you, as long as when it's revocable, meaning before you die, you can make changes whenever you like with it. So
Absolutely.
as long as you're in capacity. We talked about probate. Okay, so that's what happens when the will is executed. That's why trust helps with that. What about estate tax? Okay, so we have estate taxes and things like that. How do you build in the tax stuff, and then we'll get to the protections from creditors. So tell me about that.
Sure, absolutely. So the estate tax exemption changes year to year. And right now it's the highest it's ever been. So a lot of people think like, oh, well, it's so high, I don't have to worry about estate planning at all. But in reality, the estate tax is not the number that people should worry about. The number they should worry about is $75,000, which is where probate starts. $13 million is right now where estate tax starts. But the biggest nuance to the current estate tax exemption is the fact that there's a unified gift tax exemption. A lot of people don't realize, but in the past, you weren't able to give things away over the $18,000 a year that it is now. Used to be, 17 and 15, 14. Everyone remembers that annual exclusion that you have, but you had a lifetime gift exemption of only $1 million. So if you accidentally gave your house or gave a house to your daughter for a wedding gift, you would have to pay a gift tax on that. And I say accidentally because anyone who talked to an attorney would say, don't do that. Don't, you got to either sell it to her or put it in the trust or do something like that. But what we have the ability to do now is we have the ability to address future estate tax concerns by using, spousal lifetime access trusts or family limited partnerships. Anyone who is above a net worth of 15 million really needs to take all of the advantage of all of the options that are available today for estate tax elimination. The bonus to that, and you kind of just alluded to it, is that by addressing the estate tax concerns, you're also gaining asset protection, because each one of these nuanced plans, whether it be a limited partnership or the irrevocable trust or whatever it is, they're all shielded from outside creditors. So they shield you from the IRS, and they also shield you from anything that might happen in the future, be it a lawsuit or sometimes even a bankruptcy.
Interesting. And okay, so we talk about the tax exemption and tax protections, which are now. So, with a trust, just to kind of put a button on this, if the house or a couple million is being bequeathed towards somebody else, is that considered a gift or no? That's estate movement.
After you die, it's a bequest. It's not a gift. So it's great. It's an inheritance. And what you can, the great thing about if you have your house like you do, and your house in your revocable trust, and then you die, and then the house goes to your beneficiaries in trust, what happens is not only are you avoiding probate, but also you're avoiding capital gains tax, because the house will get a step up in cost basis at the time of your death.
Oh.
And then when your kids go to sell it, or your trustee goes to sell it, they don't have to pay any capital gains.
Wait, whereas, so if you bought it for $500,000 and now it's $1 million and is given to your child, the cost basis is $1 million?
Yes, if it's through the trust, if it's at death. As opposed to what happens a lot of older people do this, where, like, let's say your mom says, okay, I don't want to go through probate, so Alex, I'm going to put your name on my deed right now. Well, now what happens is you violate the homestead exemption, so property tax goes up. When you go to sell it, you only get a step up on half the property value, because you own half and she owned half, and you got it during her life. And there could be a gift tax implication depending on what the gift tax exemption is in that year and how much the house is worth. So it's a triple tax whammy. And I've had people call me up, and I couldn't even help them, because they called me after the fact. They say, oh, my mom, she had this house since 1975, and her property taxes just went up like from 1,000 to 10,000. And I said, well, what happened? She said, well, she put my name on the property. I was like, well, you're done. That's it. You gave away half the property. You violated the homestead exemption. You don't get that cap anymore. So it's, I always say the biggest mistake people do is putting someone they're not married to on title to either an account or a piece of real estate.
And I want all those that are listening that love to do it themselves. I'm a lawyer. I did the will myself. I got a silver.
You did an okay job.
Yeah,
but you're a lawyer. You did an okay job.
But still, there's a saying we learned in law school multiple times: the foolish lawyer is the one that represents themselves. But I am not a specialist at estate and trust law, whatever. And I can learn about it. But even still, I don't have the years. I don't know all the case law. I don't know what's specific to my state and all those things. So it's considering it's a drop in the bucket to use a professional to oversee and make sure it's there. And hey, if you're more educated like me, it's wonderful. I had a blast just talking shop. But still, I want to make sure somebody who knows what they're doing is overseeing it. Okay, so what about creditor protection with trusts?
Yes, so there are two different types of trust. There's revocable and there's irrevocable. And there's subcategories in each one, obviously. But a lot of people think revocable trusts on their own give you creditor protection. They do not. Revocable trusts are pass-through entities. So basically, they're disregarded entities. They have your own social security number as the tax ID number. You are the grantor, you are the trustee, and you are the beneficiary. On their own, they don't really do anything to protect assets. Now, as a side note, a lot of attorneys even don't realize that. And so sometimes criminal or civil litigators, or even personal injury attorneys, what they'll do is they'll see that there's a trust and they'll be like, oh, I can't touch the assets. Okay, I'll leave it alone. So, but in reality, the revocable trust is there to protect your loved ones after you're gone. An irrevocable trust, though, is completely creditor protected, because an irrevocable trust, you are only two of the three or one of the three roles. So you are the grantor, definitely, always. If you're doing an irrevocable trust for your kids, then you might be the grantor and the trustee, and you might have your kids as the beneficiaries. I actually have a structure that I have created for myself years ago, because when I got divorced, I no longer had marital protection. So I don't have a wife that I can use to jointly own assets with. So what I did was I created an LLC. That LLC has my revocable trust listed as a 99% owner. And the 1% owner of my trust, of my LLC is another trust that I created for my children. So my kids are the beneficiaries of that trust, and my ex-wife is the trustee of that trust, and that's a trust just for them, and I have no control over it. And that gives me legitimate creditor protection. It's irrevocable. And the only thing it holds is ownership in the LLC.
So, and we talked about this, and again, this is in the weeds. I just want to clarify, but for those who want to know more, talk with you. But if you are married, there's a level of protection, and then the backup is a trust. So what I'm saying is, there's certain ways. Then once you get the trust done, there's a lot of steps, and that's what a attorney like yourself helps with, and guides of how to execute it properly, so you're getting the protections of the documents. Because let's say you have a trust, but your assets are not in the trust, that's going to probate.
Absolutely.
Okay? If it's not clear where everything is unaccounted for.
Yep.
Correct. So not just getting it, then the next step from there. So we wanted to clarify, but there's a lot of, and you're just touching the surface, but there's a lot that you can talk about in terms of ways to protect assets, and you'll use whatever you can that's appropriate under the law.
Yeah, and Florida's a great state for that. Florida has wonderful asset protection laws, also has a high litigation rate, so we need them. It's both, they go in hand.
Right, and I want to clarify, you are a Florida lawyer, and,
yes.
and I asked about that earlier. So for those that are listening, because I have a few more questions, but that reminds me now, if you're in Florida, you can do everything for them. If people are not in Florida, what can you help them with?
We can still help with asset protection. We just can't help with estate planning. And the reason is that when it comes to death, every state has their own rules about, first, during life, like pulling the plug and making decisions, incapacity, things like that. And then when it comes to state inheritance tax, there are differences. So Florida has no state inheritance tax. Pennsylvania, New York, New Jersey, they do have inheritance taxes. So you'll want to use an attorney in that state when you're talking about estate tax or what happens when you die, things like that. From a creditor standpoint, though, we can work anywhere. And in fact, we do. I mean, not only do I set up Florida LLCs for out-of-state residents, I set out out-of-state LLCs for Florida residents. So we can go to Wyoming or Delaware.
Okay.
So we can use what state offers us the best protection.
I see. Okay. Now, is the trust have to be in your state?
The trust, so if it's a revocable trust, it should be in your state. Now, if you do create a revocable trust in Florida while you're a Florida resident, and then you move to Missouri, it's still valid. It's still a valid trust.
Got it.
So
Got it. Okay. So there's some things that have to be done locally, but there's also some things that can be done abroad. And when we end the podcast, we'll get your information and I'll put it available for the listeners. So if they're in Florida, definitely green light. If they're not, definitely they can reach out and see what can you help them with or answer and so on. And you're very generous with your responses either way. So did we cover, and I guess this goes into the specifically just the local trusts, but what are some other ways you can protect assets?
So there are three
besides
levels.
The trust and so on. Mm-hmm.
No, sure. And there's three types of asset protection in the state of Florida that are most prevalent. So the first is statutory and constitutional. So what we're talking about there is like homestead. Homestead is always protected in the state of Florida from outside creditors. The only creditors
let me just clarify, because let me just clarify.
Oh yeah, some people don't have homestead. That's true.
Right. Exactly. They're not Florida. So let's just we can say Florida and non-Florida. So like, for example, and homestead, I don't know if all states do that, but homestead, there's a certain tax protection. If you own the home, you get a tax break. All right. So I'm sure there are other states that do something like that. They have different levels, but you're saying there's statutory protections that are out there. So you're talking about level one?
So okay. And some states have partial homestead. Florida is probably one of the strongest full homestead protections, and not just from a tax standpoint, but your primary residence in some states, Florida specifically, definitely, but some states still have the protection where the only creditors that can put a lien on your property are creditors that arise from the property. Like you didn't pay your homeowners association, or you didn't pay the plumber, or you didn't pay your property taxes. Those can still be on your primary residence. But if you get in a car crash, your primary residence is protected. Now that's, again, specific to Florida and some states. Depends on the state that you live in. That's something that you'd have to look up. The same thing with retirement accounts, and when we talk about IRAs, annuities, life insurance, those are statutorily protected in the state of Florida. That's not in every state. California, for instance, has
Really?
no protection for any kind of those assets. But in Florida, those assets are
Really?
all creditor protected. Yeah. So if you live in
Wow.
California, move. So that's the only thing I can suggest. It's a great place to visit, but I don't know.
But not necessarily. I mean, couldn't you? I mean, even for some assets can be protected by irrevocable trusts and
Yes,
other areas like that, where you're going to have to be more creative.
correct.
And because listen, there's a lot of wealthy people in California, and I'm sure they got a smart lawyer like you that can hide and protect some things.
Well, it's funny you say that, because that is true. The next level are those irrevocable trusts, those limited partnerships, those LLCs. And this is why Nevada makes a ton of money. Like, Nevada attorneys make a ton of money off of California residents, because Nevada has very good asset protection laws, but California does not. So everyone in California moves their assets into Nevada trusts or Nevada LLCs. Now,
Wow.
Nevada does a great job marketing this to the United States as basically like, oh, we have this unique irrevocable trust that protects your assets. It's called a domestic asset protection trust, and we have it in every state. It's just a matter of what allows it or not. So Florida, we can do that. Sometimes for anonymity, we'll go to Delaware or Wyoming. But the idea is to create an irrevocable trust, which is an intentionally defective grantor trust. That way it's not negative from a tax standpoint, but your assets are protected, anything you put in there. Now, an irrevocable trust on its own, though, is not always the best idea, because you have to give up control of the asset. So that's why I had that next level of creating that multiple member LLC. So I could still be in control and have the protection. For the LLC or limited partnership, either one, a multiple member LLC or a limited partnership, are both going to receive the same type of protection. We have general partners or managing members, and we have limited partners or junior members. And it all has to do with control and voting rights and things like that. As long as the structure is honored, you get protected. Now, people hear the term piercing the corporate veil. When that happens, it's because someone decides, okay, I know how to go online to the Department of Corporations and fill out my own LLC form. I'm fine with that. So they do, and they go, look, I'm going to put my name, I'm put my kid's name, and now, boom, multiple member, and we're good. But they take all the money for themselves. When they file a tax return, it's just themselves listed as 100% owner. They don't have an operating agreement or a buy-sell agreement or a partnership agreement of any kind. And then they get audited or they get sued. And then they're told, this is a single member LLC. This is not a multiple member LLC, because you're not honoring it as a multiple member LLC. So just like you said with the estate planning, there's more work to be done after. Setting up the LLC is not why I charged for the LLC. It's because once the LLC is set up, then we need all the paperwork that goes along with it. And we need to follow the structure. We need to honor the structure.
All right. So last question, and I almost think this could be a part 2 in the future, because we're just going to cover for a few minutes. But
sure.
Our audience is mostly dentists. We do have some non-dentists for sure that listen, because it's just great business and mindset and leadership and marketing advice. But what if I own a business, particularly with a dental business, dental practice, or so on? How does that relate to my estate planning, and what do I do about that?
Absolutely. And it's from an estate planning and an asset protection standpoint. So it's funny. I've just recently, I did an estate plan for a dentist that came in, and it was a father-daughter dental practice. And part of their estate plan was that they wanted, they had 2 kids, but only one of them was a dentist, and he wanted the dental practice to go to his daughter at death. And they tried to set it up, and they told me she's a partner now, but they want to give it. And when I looked into it, they had never set up any entity at all. All it was he was just practicing. He had a DBA, like he was promoting himself under a creative name, but never had established it as an actual business. And it was because their mom was doing all of the taxes. So they had a lot of pitfalls to worry about. Now, assuming that all of the people that are on the call right now actually do have legitimate businesses that are established, what we need to do is figure out what's going to happen to that business after you die. So there's a couple different things. Number one, do you have someone that is legally allowed to run your office? So for instance, as myself as a lawyer, I can't just give my law practice to my brother who's in sales. I need someone who has a law degree, who passed the bar. to manage it. Otherwise it's going to go away. Now, maybe what I need to do in my estate plan is give a right of first refusal to another attorney that works for me, and just say, okay, one of the attorneys that works for me might want to take over the practice. If he pays my family X dollars per month over a 12-month period, he gets to keep the practice, or something like that. For every type of business, it's different. For every client, it's different. And what we want to do is we want to go over what makes the most sense for the way that practice is run. Some dentists have practices that are very similar to like a Supercuts, where people rent chairs, right? So they're of counsel. They're not really employees. But the main thing is we want to separate assets from liabilities. And the biggest liability is whenever you're touching someone. So if you have hygienists that work for you, or if you have a periodontist or an orthodontist that's coming in and using your office, any lawsuit that's going to happen, you're going to be included on. So we need to separate the dentist from the dental practice as well. We need to make sure that every place there is a chance for being sued, that is isolated from the assets. So the cash can be protected, the building can be protected, the equipment can be protected. The only thing that's being sued is this entity that is there solely for the purpose of serving. So the entity is a service business, similar to my law office. Again, my PA is my PA. It's a business.
So the dental, you recommend certainly the dentists that are working will be contractors. They'll have their own liability insurance. They'll have their own entity.
Yeah.
And then you have the dental practice. Would you recommend the dentists have an LLC for them personally, as well as the entity that owns it? So there's double level of protection potentially?
Exactly. And in fact,
so if you sue the doctor, even more so. Okay, so if you sue the doctor, they have an entity. And then you have to break that entity to get to the mother entity so those partners have entities that own the mother entity, which is the practice. So I get, and again, this could be a whole nother, there's a whole nother discussion about that. But I think that you can go, but it's important for those that are listening. Personal is important. Your business is critical. And we talked about All-Star Dental Academy. We have in the trust that we have a plan to be able to deal if something were to happen to myself and Heather, the co-founder, co-owner, like what's going to happen. And so that is all laid out and protected. And what's nice for dentists and entrepreneurs that are listening, it's not just for yourself. If your entrepreneurial venture fails, dental practice, what have you, all the people that rely on you, there's a problem. Their livelihood is interrupted because they can't legally operate without that authority. If a trust is in place, and not just that, but you have thought out these questions and you have the action, this is equally as important, is you have what is next step. Is there a dentist to back it up? Is there already a potential backup buyout or process to be able to do that? We have that in our agreement. There's a way that it can continue. We need to think about those things. And it happens. It's rare that something will happen where you don't expect. Meaning, what I'm saying, it's rare that everything goes wrong, but something will go wrong eventually. But my point is it's always better to be prepared and do it right. It's safer. You'll feel good about it. And it's a smart thing to do with respect to it. So Michael, give me some information about you, your website, your email. If people want to contact you, what's the best way?
Sure, absolutely. So my website is wfplaw.com. So that's wealthfamilyprotectionlaw.com. My email address is mwild, so M as in Michael, WILD @wfplaw.com. And the phone number is 954-944-2855. That's our office number. I'm personally at extension 1, but we have 4 attorneys that are at each of the 4 extensions that can all assist with any estate planning needs. And for some of the asset protection needs, I'm really the go-to for the asset protection component. But we also give free consultations, and everything we do is flat fee. So there's never any surprise bills. There's never any charges for meetings or phone calls. It's the project based. So we discuss what the project's going to be. I quote you a fee, give me a thumbs up or a thumbs down, and we move on from there. But there's never any surprises. So I think clients usually like that, especially business owner clients, because business owner clients tend to call me or text me, often with just simple questions, and rather than receive a little bill at the end of that. Once you're my client, you're my client. My advice is free at that point.
Well, good to know. I'm your client. I'm going to have some questions for you.
Exactly.
Michael, thank you so much for joining us. And for those that are listening, remember to follow us on Apple Podcasts, Spotify, YouTube. Get the episodes as they release. Share with your friends. And until next time, go out there and be an all-star.